Okay, Kel, could we start?
Good morning.
Good morning.
I'm speaking to you from the library of our house in Washington, D.C. And our topic is democracy and social conflict and how we govern ourselves between elections. We are seeing how the interactions of everyday life, even arguments and disputes, contribute to our self-government as a dimension of public choice, how we choose. Also, we have been exploring the nature of uncertainty in relation to ongoing inquiry. We now live in an era of great uncertainty, and we need to understand it in relation to social conflict. Pragmatic uncertainty is the early phase of a new problem, a time when competing views appear unresolved and even irresolvable. Does that mean indeterminate? No. It is easy to ignore that more information and more experience will be needed before a complicated problem can be resolved. The problem may still be at an early stage, and the overall problem cannot be resolved in an early instance. Resolution may eventually require transformed patterns of conduct, transformed preferences. Conflict is largely missing from conventional political and economic theory. To demonstrate its importance, last week I started with 3 quotes from Kenneth Arrow, Friedrich Hayek, and John Dewey. I said that these 3 very different conceptions are unique in focusing the central issue between the great polarization, defining human freedom in the sense of social, not individual freedom, and the role of government. We examined Kenneth Arrow last week, and today we examine Friedrich Hayek. Arrow was the American economist of the last century who proved the impossibility of ordering a society of fixed preferences. And Friedrich Hayek was an Austrian economist who warned against any such attempt at what he called rational constructivism. Why did we start with these 3 quotes? The purpose was to put conflict into a theoretical context, a context of theories of public choice, of public self-government. Arrow and Hayek come from opposing points of view, with 2 versions of the impossibility of democratic government: Arrow's preference theory and Hayek's spontaneity theory. And then we have Dewey's organic democracy, focusing on social problems. Another book that I will discuss is by a Brazilian philosopher and politician by the name of Roberto Mangabeira Unger. Its title is False Necessity. It's also about social freedom, and it makes a powerful argument that our societies have no essential qualities that prevents them from radical change. Society is an artifact, an idea that Unger takes to the hilt, as he says. Assuming this is true, I want to ask, what do we want? How might we answer that question? And how would we get there? Here's what Unger says on page 1 of False Necessity. Quote, "We can construct not just new and different social worlds, but social worlds that more fully embody and respect creative power. We can break a little further out of the tedious, degrading rhythm of history. We can lift a little higher the burden of social division and hierarchy that weighs upon our efforts to gain practical, emotional, and cognitive access to one another. End quote. Now, who is the we of Unger's vision when we are sharply divided into factions? The use of the term we is an omniscient we, an objective we, and it's found everywhere in philosophy and logic and in conversation. It's a common form of argument, of exposition, of a writer's point of view, as if everyone would agree. I call it the expository we, and we here need to use it with great caution and constant recognition that a real we, a universal we, simply does not ever exist, especially in conditions of social uncertainty at the beginning of inquiry, with the emergence of multiple points of view. Now, I said last week that Kenneth Arrow's model of social choice ignores John Dewey's continuum of inquiry, the fact of stages in the resolution of uncertainty that we saw earlier. It overlooks the phenomenon of group preference adaptation and transformation. You will see today that this formative continuum of inquiry is illustrated in the history and practice of Anglo-American law. Unlike models of social choice through voting, this continuum reveals how social conflict is not resolved at once and operates often over considerable time. We live in a society defined by numerous problems. Law can be seen as a cross-section of society's bigger problems and disputes. It would be very difficult for any team of scholars to make an accounting of all of the problems that are operating today in society. It would be a challenging project. But we can instead look to our record of problems and solutions in the law as an example of how legal conflicts operate, how legal problems emerge, become prominent, and lead to legal judgments. A succession of judgments may be required just to identify a common problem and suggest potential solutions. The solution may require a new set of habits and beliefs concerning what is just or right in that situation. This may seem a bit technical to many of you, but the important thing is to note that democracy depends on constant resolutions of conflict. I now turn to Friedrich Hayek, the libertarian, who argued that we can't solve problems through rational constructivism, and examine his own words about that theory. Arrow and Hayek come from opposing points of view with two versions of impossibility. Arrow's preference theory, Hayek's spontaneity theory, and then we have Dewey's organic theory, focusing on problems. But conflict is largely missing from conventional political and economic theory. To demonstrate its importance, last week I began with the quote from the very beginning of Arrow's great work, Social Choice and Individual Values. It reads, quote, "In a capitalist democracy, there are essentially two methods by which social choices can be made: voting, typically used to make political decisions, and the market mechanism, typically used to make economic decisions." Arrow's calculation, which we went through last week, led to the impossibility of ordering by voting or any other method except dictatorship. The voting paradox, noticed by Condorcet in the 18th century, had already showed by simple deduction that people voting for different preferences, called X, Y, and Z, would not be able to obtain a clear majority. Arrow's general possibility theorem generalized this to show that no rational system of ordering of any kind, other than dictatorship, is possible in a society of diverse preferences. What were the basic assumptions of Arrow's thesis? He envisions a society with a set pattern of diverse preferences at an instantaneous time, T, like the image from an all-seeing camera, a still shot, not a video, revealing all individual preferences at once, regardless of how any preferences might be either adjusting or changing in response to disputes arising from a continuing succession of public problems. I said last time that the voting paradox and Arrow's theorem both ignore the epistemology of preferences, the role of disagreement over problems, and what I called the extended continuum of inquiry into problems. Arrow's impossibility only works if the entire universe of preference-holding individuals is static within the period of observation. The model presumes instantaneous choice in an unchanging framework. Its thesis is drawn from that what I call imaginary flash camera conception of social preferences, oblivious to any dynamics of conflict. But our point now is, if change is possible within that scheme, then dispute and conflict is actually a saving force in democratic society. It breaks free from the tight grip of the impossibility theorem. How? Because there is an unspoken and unnoted fact regarding Arrow's assumptions, that the assumption of immediacy of instantaneous analysis. If there is a dispute between individuals 1 and 2 over the nature of X, and the two individuals are given time to work it out, perhaps coming to a new version of X, call it X prime, there would be no necessity of a dictator. John Dewey wrote that democracy is more than electoral politics and called for an organic democracy. He actually focused on problems and recognized the continuing nature of social inquiry, which is incompatible with the static image of an omniscient camera. Problems define the real nature of uncertainty, which I said is quite distinct from indeterminacy, and uncertainty leads us individually or together as a society into inquiry, and through what I call the stages or phases of inquiry. Uncertainty is the initial stage. What then is Hayek's vision? Hayek said that political choices are so complex that we must rely on a spontaneous order, as if our lives are beyond the competence of human planning. Even democratic legislation poses a threat to individual liberty, leading to authoritarianism and tyranny. So with Hayek, the question arises, what is the method of human control in the continuum? Where is the element of human freedom? One of the phrases made notorious by Hayek was rational constructivism. What he meant by constructivism is the notion of finding a formula, and the best formula, for structuring or constructing our society. I call this the architectural view, as it suggests starting from scratch to design a building on an empty lot. But Hayek insists, quite rightly, that human society is not comparable to an empty lot. It is filled already with customs and habits that direct much of our civilization. There has been some debate over whether Hayek himself was rigidly resistant to any human construction. So let's take a look at what he wrote. When he went to the University of Chicago in the 1950s, Hayek got to know another influential and conservative economist by the name of Frank Knight. They had a friendly disagreement. Knight respected much of Hayek's thought about spontaneity, but he also believed that there must be some form of human control, some more constructive view of human agency. He accepted Hayek's respect for custom, but he was deeply concerned over the future of liberal democracy. If we are purely creatures of an unplanned history, as Hayek appeared to say, we have no freedom to chart our own course. And this was especially true if our preferences are fixed, as Arrow said in 1951, and as the sociologist Amitai Etzioni warned recently, if our preferences are immutable, we are either blessed or lost from the onset. The game is up before it has begun. So, while Hayek looked to custom and spontaneous order, Frank Knight sought a more constructive approach in the give and take of political discussion. But despite considerable effort over a long period, Knight never came up with a concrete program for how it should work. Other theorists who study aspects of constructive discussion have also tried, and we'll talk about them later. Jürgen Habermas, who proposed a discourse ethics, and John Rawls, in his theory of justice, has a discursive model engaging how deliberation can reach a balance of viewpoints, a reflective equilibrium. Yet even these discussion-based models would be hopelessly ambitious if individual preferences are so rigid that no realistic account of democratic discussion could alter them. Discussion-based theories assume that disagreements can be resolved, and they try to show how a logic of discussion works. My question is, how do they overcome the twin impossibilities of Arrow and Hayek? As we look around this country and the world today, dispute and conflict are rife. Human habits are involved, conflicting ones. So how can they be adjusted, even transformed, to meet the great challenges of our time, such as climate change? So far, the discussion has been very general, based on abstractions like preferences, discussion, freedom, conflict, and change. We haven't looked for examples. We need facts to address this problem. And today, we look at the law. What is the historical experience of legal conflict, of legal litigation, its effect on preferences, and its use of discussion? There are lessons to be learned in the law's relation to social problems and even to legislation. As some of you may know from my earlier lectures, my account of law and its growth draws on pragmatist conceptions, and the law not just as a code of rules, but as a system of inquiry, a continuum of inquiry. And I will examine the gradual, incremental growth of extended judicial inquiry, dealing with that old problem of uncertainty. What do we actually do, not just individually, but socially, to survive uncertainty? I want to show that in the law, there can be a process of reflective preference adjustment. There can be an element of human freedom and control, but its operation is complicated and varies from one situation to another. It is not like Arrow's pure ideal theory of human rationality or Hayek's abstract idea of spontaneity. What does the reality of our life look like? Let's turn to the disagreement between Hayek and Frank Knight over constructivism and spontaneity. What in the writings of Knight and Hayek is the precise nature of Knight's constructivism and Hayek's spontaneity compared to the actual experience of urgent problems when we look to the law courts? Can a theory of evolution through spontaneous order be supplemented by an account that recognizes some form of public deliberation of inclusive discussion? I think that both Knight's constructivism and Hayek's spontaneity leave room for a middle ground between the two positions, opening insight into the conditions of democratic problem solving, of its success and failure. Both opposing positions, spontaneity and constructivism, are abstractions. They fail to inquire into the variable and contingent factors governing problem solving and conflict resolution. What does Hayek say in defining spontaneity? First, he identifies custom as the core alternative to constructivist rationalism. And he says this, quote, "Many of the institutions of society which are indispensable conditions for the successful pursuit of our conscious aims are in fact the result of customs, habits, or practices which have been neither invented nor are observed with any such purpose in view." If they're not, that's the end of his quote. If they're not invented, how then are they created? And how do they achieve those conscious aims? What creates social order? Hayek says the spontaneous order just evolves. Quote, "The orderliness of society was not due solely to institutions and practices which had been invented or designed for that purpose, but was largely due to a process described at first as growth and later as evolution, a process in which practices which had first been adopted for other reasons, or even purely accidentally, were preserved because they enabled the group in which they had arisen to prevail over others." That's the end of his quote. There's not much deliberation or discussion there. What governs Hayek's model of evolution? It draws heavily from the notion of Darwin's mechanism of survival of the fittest, of how a species survives and propagates itself. The prevailing system of rules, writes Hayek, has been preserved because, quote, "groups who practiced them displaced others," end quote. Conflict among such groups is implied, but Hayek provides no clear account of how the rejected groups yielded to the successful ones, or how conflicts among them are settled. Instead, his argument turns to a general discrediting of the opposing constructive model of order. Quote, I attempt to show that certain widely held scientific as well as political views are dependent on a particular conception of the formation of social institutions, which I shall call constructivist rationalism. End quote. What's that? He says it is, quote, a conception which assumes that all social institutions are, and ought to be, the product of deliberate design, end quote. Here, by associating constructivism with design and contrasting it with custom, he must mean something like starting from scratch. Think of an architect planning a complex building. There's nothing there yet, just an empty lot. Does legislation really always start from scratch, from an empty lot? Hayek's label implies that all legislation is de novo, with all relevant facts having to be recognized and addressed at once, rather than drawing on prior inquiry or even prior custom. It does sound rather totalitarian and coercive when you conceive of it that way. And that's exactly what some in society are saying about social problem resolution through legislation. It also posits a limited control group, even if popularly elected, dictating solutions for everyone else. Have you heard that? But without any human construction, how have Hayek's customs come about? How have his prior rules emerged, whose purpose or origin, he says, we often do not know? How did they already come into existence? Studies of law can illuminate how such rules have emerged and adapted, and their supposedly unknown history. From legal history, it can be shown how habits and practices, if not custom itself, are subject to incremental transformation through ordered judgment. Hayek asserts that a major reason why constructivism fails is the natural complexity of the matters subject to human ordering. This complexity is such that no immediate encounter by a legislative body can grasp its extent and importance. But legislation is usually a response to discrete problems. How do problems get identified and defined? By particular instances, one after another. Legislation is usually preceded by considerable prior experience, including innumerable disputes. Now, a prime cause of Hayek's doubt lies also in his skeptical view of reliance on abstract formulas like social justice. This came up in his discussions with Frank Knight. The question was one of method. In responding to social problems, do we rely on abstract formulas in a method that is primarily deductivist, detached from particular experience, or do we work from particular experience itself? And if so, then how? As I say, in a continuing process of incremental ordered judgments, potentially extending over sufficient time and experience to grasp and adapt to complex problems, incremental judgments address resistant disputes case by case. They generalize retrospectively after they have, in multiple disputed situations, encountered, identified, and addressed critical elements and conditions bearing on the ultimate resolution. They can incrementally affect gradual preference adjustment and revision of resistant habits and practice, along with the process of inquiry. I think Hayek actually opens the door to this. He mentions practices in a context that suggests that they are in fact subject to change. He says this, quote, "The important insight to which an understanding of the process of evolution of law leads is that the rules which emerge from it will of necessity possess certain attributes which the laws invented or designed by a ruler may but need not possess, and are likely to possess only if they are modeled after the kind of rules which spring from the articulation of previously existing practices." End quote. So, Hayek offers no account of how such previous practices might have changed other than by spontaneous evolution. Let's look at how adjustment and transformation can happen in the law with the growth of legal precedents. First, are legal precedents spontaneous or constructed? There is an element of both. Precedent has been described as ratio decidendi, matter previously decided. This is a conventional characterization, but the context in which precedent is cited generally implies an element of both novelty and dispute. Alternative interpretations of a new dispute are usually supported by sets of opposing precedents. Just look at the practice of appellate lawyers, citing strings of cases on opposing sides, previous judgments, and previous opinions. Legal precedents are actually clusters of prior comparable decided cases or judgments. Embedded practices are often the resistant force behind opposing precedents, as in Edward Levy's famous example of a century-long dispute between consumers and manufacturers over dangerous products, or Justice Holmes's 1873 example of construction on the boundary between neighboring landowners. Previously settled practices clash at the boundary on either side of a new dispute. They conflict at the edge of otherwise accepted practices. One landowner's natural interest improvement on a boundary line interfering with another neighboring landowner's interest in light and air. A modern example is the relatively new problem of euthanasia or assisted death, when a patient with severe pain and a terminal disease asks for medical assistance to end their life. Each decision stimulates a response within the relevant affected community of other landowners or other patients who must adapt or be liable to a similar complaint. This feedback loop from the community affected by particular judicial decisions leads to incremental group preference adjustment as a novel problem is identified and a remedial practice is adopted and enforced through the courts. It is only after a sufficiency of decided examples that a new practice becomes sufficiently evident for a general rule to be put in place. This approach is both inductive and empirical, seeking guidance retrospectively from case-by-case exploration. It enables a gradual transformation of conduct to occur in concert with the emergent articulation or revision of rules. How is adjustment possible? Courts cannot legislate. They can only settle specific disputes under present facts. But in the process of successive legal arguments, alternative paths are displayed and compared as new disputes comparable to others are added to the account. It bears emphasis that this process does not necessarily rely on abstract formulas like social justice, and ideally should not do so. It does not start with abstraction, but finds it, and generalization of principle retrospectively rather than in prior deductive recourse to axioms like social justice or ideology. The scholar Edward Levy described the process of extralegal feedback from outside the legal profession and the adjudicatory process in 1949. And he wrote, quote, "It appears that the kind of reasoning involved in the legal process is one in which the classification changes as the classification is made. In a sense, all reasoning is of this type." And here he cited John Dewey's 1939 logic, the theory of inquiry. But here, said Levy, is an additional requirement which compels the legal process. Not only do new situations arise, but in addition, people's wants change. The categories used in the legal process must be left ambiguous in order to permit the infusion of new ideas. Levy's account matches and illuminates one from Justice Holmes in early essays in 1870 and 1873. How is legal conflict resolved? Generality of rule follows a process of successive judging and later expressing the path taken. At first, a meandering trail of particular decisions favors neither side and requires patient examination. The final expression may be a negotiated formula. Holmes in 1873 described the drawing of lines between opposing poles. Quote, "The growth of the law is very apt to take place in this way. Two widely different cases suggest a general distinction, which is a clear one when stated broadly. But as new cases cluster around the opposing poles and begin to approach each other, the distinction becomes more difficult to trace. The determinations are made one way or the other on a very slight preponderance of feeling rather than articulate reason. And at last a mathematical line is arrived at by the contact of contrary decisions, which is so far arbitrary that it might equally well have been drawn a little farther to the one side or the other." I'll explain this quote in later lectures, but let me go on to what Levy says in his reflection. Quote, "The law form is the most explicit demonstration of the mechanism required for a moving classification system. What does the law form require? It requires the presentation of competing examples. The form protects the parties and the community by making sure that the competing analogies are before the court. The rule which will be created arises out of a process in which the differences have been urged. In this sense, the parties as well as the court participate in the lawmaking process. In this sense also, the lawyers represent more than the litigants. As Levy says, the determination of similarity or difference is the function of each judge. A feedback mechanism is essential to the idea that the legal process responds, at least approximately over time, to the relevant community's idea of fairness." And here's another quote. He says, "Reasoning by example in the law is the key to many things. It indicates in part the hold which the law process has over the litigants. They have participated in the lawmaking. They are bound by something they helped to make. Moreover, the examples or analogies urged by the parties bring into the law the common ideals of the society. The ideas have their day in court, and they will have their day again. This is what makes the hearing fair, rather than any idea that the judge is completely impartial. For of course he cannot be completely so. Moreover, the hearing in a sense compels at least vicarious participation by all citizens, for the rule which is made, even though ambiguous, will be law as to them. So it's judicial recognition of a process of social adaptation that permits the convergence of practices with opinion. Levy identified 3 stages of inquiry into disputes between sellers and consumers of products that have caused harm or loss. The first stage, he says, is the creation of the legal concept, which is built up as cases are compared. The period is one in which the court fumbles for a phrase. Several phrases may be tried out. The misuse or misunderstanding of words itself may have an effect. The concept sounds like another, and the jump to the second is made. The second stage is the period when the concept is more or less fixed, although reasoning by example continues to classify items inside and out of the concept. The third stage is the breakdown of the concept, as reasoning by example has moved so far ahead as to make it clear that the suggestive influence of the word is no longer desired. Well, now this is a very particular and interesting view of the stages, the phases of inquiry. And I don't say that they are universal, that Levy is absolute and correct in the way he just described it, because we'll go forward and look at the way John Dewey suggests this continuum of inquiry applies not just to the law, but to ethics and morals and society in general. But in actuality, the process, which we'll refer to again and again, it's anything but systematic, as the courts may search with mixed success for uniform rationales. In an inquiry that played out over a century, Levy showed that it takes persistence and judicial creativity for success. But if preferences are fixed, no hope would exist for the settlement of conflicts among opposing patterns of conduct. In the struggle for peaceful settlement of labor disputes that arose with the turn of the 19th century, ultimate credit is generally given to legislation. But the legislation came late in the game, well over a century and a half after the earliest disputes. Justice Holmes, while a state judge, first encountered the problem of union workplace picketing in 1895, and his dissents in 2 cases that ruled picketing illegal contributed to the rationale for its ultimate legality. Labor legislation grew out of judicial exploration and remains dependent on judicial inquiry to frame its adaptation. Edward Levy showed that rules change from case to case and are remade with each case. Yet, he writes, this change in the rules is the indispensable dynamic quality of law. It is a system of rules, and the rules are discovered in the process of determining similarity and difference. His account of legal inquiry suggests an important insight into the problem of adjustment within the customary order. Hayek was undecided, or at least equivocal, as to how adjustment was possible. On one hand, he attributed development to orderly structures, which are the product of the action of many men, but are not the result of human design. While on the other, he said that social structures owe their persistence or extinction to their tendency to increase or decrease the efficiency of the group as a whole. This suggests a contradiction over whether the spontaneous order derives from micro or macro level properties, as well as the source of social adaptiveness. There is a contradiction here, which Levy's vision should help us to understand and resolve. Hayek posits 2 distinct and inconsistent accounts of the maintenance of social order. One emphasizes local adjustments by individuals, somehow giving rise to social structures, and another emphasizes the effectiveness of intergroup competition. Legal induction accounts for both levels. It shows how individual preferences are aggregated in the context of specific problems and how they operate as group preferences in the process of dispute resolution. My later lectures will examine this in more detail, but first, let's turn to Frank Knight's concern over the element of discursive reflection in social ordering and the problem of human control. A scholar who studies Frank Knight uncovered an interesting remark that Knight made in a letter to Hayek in 1934. Knight questioned whether, quote, systematic exposition, rather than the meeting of specific questions, is the way to advance knowledge. And he wrote, quote, I am strongly convinced of the opposite. The context of this letter was Austrian capital theory, but Knight hints at a larger disagreement with Hayek on method that aligns him with Levy and Holmes. The systematic exposition to which Knight objects refers to Hayek's preferences for broad generalizing regarding fundamental issues in economics rather than meeting specific questions. So in saying this, Knight favors a particularist, experiential method of advancing knowledge. It's too bad that Knight and Edward Levy, who were both writing contemporaneously at the University of Chicago, did not get together and collaborate and learn from each other's views. In understanding how an incremental constructivism can attain a degree of practical rationality, Levy might have suggested to Knight how legal generalization arises from meeting specific questions in litigation. So despite their disagreement, Knight accepted Hayek's view of custom in resisting revision, as well as his skepticism of deduction from vague generalities like social justice. However, in his sweeping critique of constructive rationality, Hayek did not resist deduction from a broad abstract notion of spontaneity. Knight, in rejecting Hayek's dismissal of directing human action through discussion, suggested that agreement does not come from generality, but from particular instances, what he called the prospect of agreement on concrete injustices. So this is consistent with the empiricism of Levy and Holmes and their incremental ordered judgment, and Levy's reasoning by example. We find important common ground in Knight's view that agreement is possible on concrete injustices, not abstractions like social justice. The difficult question for the theory of public choice is how this can occur. Knight's prospect of agreement is an apt phrase. Agreement emerges not all at once in a forum of discussion, but through a continuum of inquiry from one case to the next, as similarity is found among events distinct in place and time. Agreement among opposing groups is not verbal assent, but arrives through practice and must be secured with the coordination of opposing patterns of action. Knight's ideal of a free society in his quest for agreement by discussion in actual experience comes retrospectively in successive ordered judgment, which advances in response to those specific questions or particular problems, rather than systematic exposition of abstract positions. Hayek's spontaneity recognizes the resistance of habits and practices to abrupt and jarring change. It lies in the continuity of habits and patterns embodied in legal precedent that he summarizes as custom. Precedents embody habits and patterns that are often affirmed through prior conflict in legal rules. New conflicts arise presenting continuing conflict and the need for revision. This model is not ideal or formulaic, and the process is clearly open to abuse when you consider the role of money in litigation and politics. But Hayek's account lacks a convincing account of how private ordering works, especially how conflict contributes to the groundwork for rules and solutions. Levy's account is closer to reality, but it should not be interpreted as an ideal account. In stressing the positive, while recognizing the many ways in which resolution is fragile and difficult, if not perverted or undermined by contrary influences, Levy seeks a non-ideal theory, meaning that the successful outcome of the process is not assured, but is contingent on positive action by the parties and unbiased decision by judges. It is not a smooth process, nor one that finds quick or perfect results. Frank Knight would certainly not call such a process systematic, yet there is powerful evidence that to be successful, the process involves preference change, if not by the individual actors in each case, then by successive actors in comparable positions. So remember the comment that I quoted from Amitai Etzioni, that if preferences are fixed, human freedom is doomed. The problem set forth by Etzioni is, quote, to what extent we are creatures of history as against being free to chart our own course. He warns that our future is at stake in this question. Quote, if our preferences are immutable, we are either blessed or lost from the outset. Contemporary economics has little on transformation, and it assumes that preferences are fixed. Recall what I said when I mentioned Roberto Unger's book, False Necessity. I said, who is the we to whom he refers when he says we can recognize that society is an artifact and there is no natural limit to change? Preference change, its adjustment and transformation, is important to understand before we can get beyond Arrow's restrictive vision and the language of utilitarianism. I suggest that change reflects the real world of conflict, and preference change will help us to understand not just law, but the dynamic element of ethics and morals. Levy displayed the transformation of language through his three stages of inquiry into disputes between sellers and consumers of products that have caused harm. Next week, we will consider this problem as part of a more general discussion of pragmatism's radical departure from utilitarianism. Utilitarianism has been a dominant and clearly ideal form of political theory, and philosophy for many generations has adopted utilitarianism as its basic model. As an ideal theory, it has two major problems: whether it can be actually achieved and whether it proves too much. Would utilitarianism justify hanging an innocent person if that would stop a crime wave? Utilitarianism assumes a vision of fixed preferences, and it's clearly related to Arrow's vision of society. We'll also turn to a study of the career and contributions of John Dewey. Dewey wrote that democracy is more than electoral politics and called for an organic democracy. We also saw that he focused on problems rather than Arrow's utilitarian preferences. He recognized the continuing nature of social inquiry, what we call the formative continuum. This is incompatible with the static vision of that omniscient camera. An important aspect is the constant dependence on human experience as a guide to knowledge. And in Dewey's time, this led him to explain how important experience was to guiding the natural sciences, but how easily it was ignored in guiding ethics and morals. Dewey encountered constant resistance to his explanations. You might say, as I do say, that it was more than just a failure on his part. It was a general habit of thought throughout society and academia that resisted him. Even today, despite pragmatism's deeply critical response to utilitarianism, contemporary pragmatists have often failed to explain their own advantages. This will be important to our overall consideration of democracy and social conflict. It will lead us directly into the subject of contemporary ethical theory. Today's pragmatists have been too insular, too concerned with their own issues, unwilling to challenge the main currents of philosophy. So now that you hear the 10 o'clock chime in the background, it's time for me to end my presentation, turn the discussion over to Professors George and Pedro, and I'll see you next Monday in our next lecture on John Dewey. Thank you.
Carol, thank you very much for your beautiful presentation, and we will wait next week for your ideas about Dewey democracy. That is very, very, very important. I see you. Pedro?
What did you just say?
Bem, well, now I would like to eu vou falar com vocês que estão assistindo e agradecer a participação. Acho que hoje, em virtude do feriado espremido, nós tivemos uma audiência um tanto quanto reduzida, mas isso é só uma questão episódica. Na próxima semana nós estaremos todos aqui juntos para ouvir o professor Kellogg falar sobre um dos maiores pensadores, idealizadores da democracia, que é o John Dewey. Bom dia para todos.